Good evening, everyone. Today I will be explaining the concept or definition of original registration under the Torrens system. So, the original registration refers to the first step in registering a parcel of land under the Torrens system. This happens when a previously unregistered parcel of land is officially brought under the system's jurisdiction through an administrative and legal process. Once this is done, the Register of Deeds issues a original certificate of title. That certificate of title serves as an official document ensuring the owner's name and the title of the land.
The purpose of original registration is to establish lawful ownership of the land. It helps protect landowners against fraud and simplifies future land transactions such as selling, transferring, and mortgaging the property. Through registration, a public record of ownership is created, and the land is officially brought under the Torrens system. Most importantly, it ensures state-guaranteed protection, meaning the government recognizes and safeguards your ownership rights.
For the legal basis, first we have PD number 1529 or the Property Registration Decree. This is the main law that governs all the registration processes in the country. It combined and updated all their laws under the Torrens system and explains the steps for registration, the court's role, and how titles are managed. It also made the regional trial courts handle land registration cases. Next is Act number 496 or the Land Registration Act. This was the first law that introduced the Torrens system in the Philippines. It created a legal way to confirm and record land ownership and established the Court of Land Registration and the Registers of Deeds. Even though it was later replaced by PD 1529, it remains the historical foundation of land registration. Lastly, we have CA number 141 or the Public Land Act. This law controls the classification and registration of public lands. It allows long-time occupants of public lands to apply for ownership if they have used the land openly and continuously. This helps secure ownership for long-time settlers.
So let's talk about the land registration process. First, a licensed surveyor creates a detailed map showing your land's boundaries, size, and location. So this map needs to be accurate and approved by the right authorities. Second, make sure your survey plan is acceptable to the court and other involved agencies before you officially file anything. Third, submit a formal application to the Regional Trial Court or RTC in the area where the land is. So this follows the legal process. So the court announces the application to the public, so anyone who might have a claim to the land can come forward and object. And then the court reviews all the evidence and decides if you have the right to register the land. And if they agree, they'll issue a judgment in your favor. After that is the decree issuance, where the Land Registration Authority or LRA creates an official document, which is the decree of registration. So that leads to your land title. And lastly, so the LRA sends the title to the Register of Deeds, who records it. And once recorded, you'll receive your official land title.
Here are the responsible agencies on processing original land registration in the Philippines. So we have here the Land Registration Authority or the LRA, Registry of Deeds, Department of Environment and Natural Resources, Land Management Bureau or the DNR LMB, Court or Commissioner of Land Registration, local government units which are municipal or city assessor and treasurer, Bureau of Internal Revenue or the BIR. So the LRA oversees title declaration and issuance, while the Registry of Deeds records and maintains public access to land titles. The DNR Land Management Bureau handles land surveys and cadastral data essential for accurate registration, especially for original titles, while the courts establish the legal basis for registration, after which the Commissioner of Land Registrations issues the title. Also, the LGUs document ownership through assessment and taxes, ensuring compliance. Lastly, the BIR ensures all taxes are settled before title registration or transfer.
So following the responsible agencies na naman ganyan ni Kim na involved sa original registration of land, dili na punta sa medyo tricky na aspects sa land registration. Walang iba, kundi ang, yes, mga paperworks. And at this juncture, we'll be going through a quick description about unsa and asa ma-process ng mga documents. So, starting with the proof of ownership. So, ginapagitaan niyo mismo na ikaw ang legal owner sa isa ka land. Pwede na siya deed of sale or donation, and usually ginaprocess siya through the Registry of Deeds or isa ka notary public. Now, following that is a technical description of approved survey plan. So, muna ang mga ginaprepare sa mga GE na nag-contain sa exact boundaries and coordinates sa isa ka land. And gina-approve lang niya siya by the Land Management Bureau or ang DNR. Now, next na po na is ang declarations of receipts. So kani, gikan niya siya sa city or municipal assessor's office and the treasurer's office, proving that the property taxes has been paid. And aside na, need po ng affidavits of possession. Muna ang sworn statements from you or witnesses proving continuous possessions of the land. Now next are the clearances from the government agencies like DNR, DAR, or NACP, which depends sa classification sa land and also sa location sa land. Now, finally is the application and filing fees which are submitted to the Registry of Deeds or Land Registration Authority para masugdan na ang registration process. And yes, sugod na lang to. So, basically, these are necessary documents that ensures that the land ownership is properly verified, surveyed, and more importantly, recorded under your name. So, with that, let's proceed muna sa common challenges or issues na pwede natin ma-encounter in the context of original land registration.
I'm going to discuss the common challenges or issues under the original registration or the PD 1529. First is Proof of possession. One of the main challenges in original registration is proving open, continuous, and exclusive possession of land since June 12, 1945, as many applicants cannot present complete evidence or records, especially if ownership was passed down through generation without proper documentation. Second is survey problems. Another issue is inaccurate or incomplete land surveys. Boundaries are sometimes unclear or overlap with neighboring properties, making it difficult for the court to identify the exact area being applied for registration. Third is publication and notice. The law requires notices to be published and sent to interested parties, but in practice, not everyone receives them. Some notices fail to reach rightful claimants, which can lead to oppositions or future disputes after the registration process. Fourth is third-party interest. While the case is still pending, the land may be sold, mortgaged, or otherwise encumbered. These third-party transactions can complicate the process because the court must consider who has the stronger or rightful claim. Fifth is cost and time. The process of original registration is often costly and time-consuming. Applicants must pay for surveys, publication fees, and court hearings, and due to heavy workloads in the court, cases are often delayed.
Next, ownership, identity, and marital status. Applicants must clearly state their citizenship, civil status, and ownership details because errors, missing info can invalidate a title or delay registration. For example, if a married person registers land under only one spouse name, it may create ownership disputes later. Number 2, finality and irreversibility after 1 year. Under land registration, once a decree registration is issued under 1 year, it cannot be reopened or changed except for cases of actual fraud. These principles protects the Torrens system indefeasibility of a title. 3. Lost or incorrect records and duplicate certificates. Land title may be lost, damaged, or duplicated due to mishandling or natural disasters. These can be reconstituted through the court, but discrepancies or missing record can cause a serious legal issues. 4. Land classification, agrarian reform, and agricultural land issues. Land use for rice, corn, agricultural purposes is covered by agrarian reform laws, meaning there are strict limits and process of ownership and transfer. Some agricultural land cannot be freely registered or converted without government clearance. 5. Overlapping titles, boundary conflicts, and leftover parcels. Sometimes large parcels are subdivided or sold without proper subdivision plans or proper surveys. This leads to overlap or unregistered leftover portions. Section 58 of PD 1529 requires a subdivision plan where only part of registered land is conveyed.
Let's proceed to real life example or application. So the proving open, continuous, and exclusive notorious possession. The scenario reflects the case of Republic versus Kara MGR number 197389, March 22, 2017, where the Supreme Court ruled that consistent, visible, and undisputed land possession constitute valid proof of ownership for original registration. So next is survey technical description and boundary issues. The situation reflects case Cambridge Realty and Research Corp versus Eridanus Development Incorporated, GR number 152445, September 14, 2007, where the Supreme Court highlighted that survey errors and inaccurate technical description lead to title dispute, emphasizing the need for accurate and verified surveys and land registration. Next is the publication notice in the position procedure. The scenario reflects the ruling in Republic versus Court of Appeals and Naguit, GR number 14507, January 17, 2005, where the Supreme Court emphasizes that proper publication and notice are jurisdictional requirements to ensure fairness and protect the rights of all interested parties in land registration cases. Next is the person claiming an interest may file an opposition. So this reflects in ruling in Director of Lands versus Intermediate Appellate Court, GR number L-73002, December 29, 1986. So where the Supreme Court affirmed that any person or entity with an interest such as government may file an opposition in land registration to ensure fairness and protect valid claims before the title issue. So next is dealing with dealings or encumbrances meanwhile. So this mirrors the ruling in Hears of Eugenio Lopez Sr. versus Enriquez GR number 14662, January 21, 2005, where the Supreme Court emphasized that dealings or encumbrances during pending registrations are valid but must be reported, so they are properly annotated under Section 22 of PD 1529. Next is the time, cost, and resource constraints. So the scenario here illustrating how financial burdens, slow bureaucratic procedures, and limited access to agencies hinder ordinary landowners from completing original registration and expose them to potential disputes.
Another real-life examples or application is the ownership, identity, and marital status issues. So in Spouses Bueno versus Spouses Bautista, the case involved the sale of a conjugal property made by the husband without his wife's consent. The question was whether the sale was void or merely voidable, and the court ruled that it was only voidable, meaning it can still be validated later on, not automatically invalid. Next is the finality and irreversibility after 1 year. So in the case of Dar Secretary versus Dumagpi, ang issue dira is whether land titles issued under the Torrens system can still be challenged after 1 year. And the court ruled that once a title becomes final daw, it can no longer be annulled or changed after that 1 year period, ensuring stability of land ownership. Moving on to lost or incorrect records and duplicate certificates. In the case of Heirs of Spouses Ramirez versus Abon, the court tackled a petition to reconstitute a lost duplicate title, and the ruling stated that registered owners must be notified before any reconstitution. So without such notice, the petition is invalid. So for land classification or agrarian reform issues, we again refer to Dar versus Dumagpi na case. And the court held that agrarian reform titles fall under the exclusive jurisdiction of the DAR, not the regular courts. So last but not the least, we have overlapping titles or boundary conflicts. In this case, two parties claim the same land using titles from the same original certificate, and the court decided that the earlier title prevails and any later duplicate registration is null and void.